Good afternoon, everyone, and welcome to the webinar that we have today discussing President Trump's recent executive order ending government support for programs promoting diversity, equity, and inclusion, and the mandate that followed from the United States Department of Education Office of Civil Rights. I'm Dr. Tracy Frederick, the Director of Engagement and Strategy for the Kansas School Board Resource Center. I'm here with Ward Cassidy, our Executive Director for the Kansas School Board Resource Center, and our two panelists from the School Boards for Academic Excellence Kansas Legal Hotline team, Ryan Kriegshauser and Josh Ney from the Kriegshauser Ney Law Group. Now, you all will remember, what brings us here actually is that you all remember on February 14th, the U.S. Department of Education's Office for Civil Rights issued a Dear Colleague letter demanding that state agencies and school districts remove all diversity, equity, and inclusion programming from school district curriculums, and warning that failure to comply with the directive by February 28th could result in cuts in federal funding. Now, we can all understand that this can cause confusion and a lot of questions. There are probably a lot of unanswered questions out there regarding school board responsibilities with this issue. Josh and Ryan will provide an overview of the ORC letter and discuss the legal implication for school boards under the new directive. But before we begin and open this discussion up, I want to go over a few logistics in case you are new to our webinars. If you have a question, please put your question in the Q&A box and I will ask the panelist for you. And also, we're recording the webinar, so you will receive a link to the recording to review and share. It will also be archived on the workshop section of the KSBRC webpage. Now, I don't want to take any more time away from our panelists. We may have a stop at 5 o'clock, so I want to turn it over to Josh, and he will set the agenda. He and Ryan will set the agenda and help us understand the letter, the executive order, and the implication for school boards. I'm going to turn it over to you guys, and you can take it away.
Thank you, Tracy, and welcome everyone. We're glad to, Ryan and I are glad to be able to continue to participate in these educational webinars. Ryan and I are attorneys in Kansas that have dealt with various issues, both in representing governmental entities and school boards, as well as representing individual plaintiffs or other situations for students and families that may reach the court system or an administrative process. And so we're doing our best to kind of navigate the new waters, so to speak, that are coming down from a change in administration at the federal level, as everyone across the country in courts and school boards and state associations process these new directives. And so we're wanting to definitely get to your specific questions, but I wanted to at least do a couple overview so we're overviews of these Dear Colleague letters that were issued recently by the Department of Education, United States Department of Education, Office of Civil Rights, that really have raised a lot of these questions. Obviously, anytime you have a switch in administration, there are new executive orders, there's new guidance documents, there's new enforcement documents that explain how that particular administration is going to interpret and enforce the law, and this administration is no different. These particular letters that were issued come on the heels of executive orders from President Trump that are more broad in nature. Those executive orders have to do with various DEI requirements, establishing interpretation regarding gender limited to the two sexes, other types of executive orders, but they really don't have they don't create a private right of action. They're very express in the executive order language that this is not necessarily creating new law as it respects to claims that certain persons could bring in court, but rather how the existing federal government Department of Education and the DOJ are going to enforce the laws that have been on the books for some time and the regulations. And so the two letters that we wanted to bring and discuss today are not only the February 14th letter, and I'll share my screen here just so everyone's on the same page. Can everyone see that?
Yeah. No.
Okay. So this is the February 14th letter, and this has to do with the Title VI of the Civil Rights Act, and it is addressing race-based discrimination. This is something we'll talk about today, but it's applies to both universities and K through 12 schools and districts that would receive federal funds. Quite a bit of this particular letter has to do with the Supreme Court's 2023 decision in Students for Fair Admissions versus Harvard, the case that clarified that the use of racial preferences in college admissions is unlawful, and sets forth a framework for how they're going to evaluate race-based classifications in the application process at the college level. But it does go on to talk about K through 12 districts and schools that would have any type of race-based discrimination programs. And obviously that includes not only curriculum that we've seen pop up in the last several years surrounding critical race theory and other types of diversity, equity, and inclusion type curriculums where there's specific content that that talks about race in a novel way, and we can, I think most of us are familiar with some of the controversy surrounding that, but also clubs and other types of activities that would occur at the K through 12 level that may have been around for a long time, may be relatively new, but ultimately the question is whether there is some sort of race-based segregation or race-based classification that gives access to various activities on the basis of race. And this letter really is saying that if you're accepting federal funds, then that you come under the purview of the Office of Civil Rights for the Department of Education. And this is really a sea change from the previous administration to say that now if you are engaging in any type of race-based discrimination for any race, and that can be not just historic minority races, but Caucasian and other races as well, that those types of programs could come under scrutiny and even investigation up to and including the loss of federal funds. And so that's the first resource I'd want you and your school board attorneys to be aware of. I'm sure your school board attorney is aware of that, and we're monitoring daily kind of the news. There was just a lawsuit that was filed by the National Teachers Union challenging some of this. And so we'll be monitoring that. That was filed in the United States District Court for the District of Maryland. So this is really an evolving issue. The second letter that I wanted to point out was actually February 4th, and that had to do with the Title IX rule, which is a sex-based discrimination law that we had two different rules ultimately that were promulgated. One was in 2020, Title IX rule that had to do with sexual harassment. And then there was a more recent one that was the final rule was promulgated in 2024. And that rule was recently vacated. That more recent rule that was promulgated under the Biden administration was vacated in a court ruling, and the Dear Colleague letter from February 4th talks about that, and that the Trump administration and specifically the Department of Education will be following the regulatory framework of the binding Title IX enforcement provisions that include principles and provisions of the 2020 rule, the 2020 Title IX rule. So there are a lot of resources available that the Department of Education has provided. One of them is on the United States Department of Education website related to that Title IX rule. And then there are resources pertaining to the 2020 Title IX rule that are available. And if you click there, it will actually give you lots of different fact sheets and summary of the major provisions of the Department of Education Title IX final rule, summary of the major provisions and comparison to other provisions, and some technical assistance and guidance, including online and digital sexual harassment under the 2020 Title IX regulations, a resource for students, families, and educators. And so ultimately, those are, we're really just trying to give you today a place to start, and for your board and your superintendent and your school attorney, school board attorney to start in navigating this, because we don't really know what we don't know. The one overarching thing that I would say that Ryan and I are going to talk about today as a theme is that even though this feels like a very significant sea change, and no school district likes to be threatened with the loss of federal funding, in terms of the actual applications of law, what we really see this as is more of a reset button to how we all understood civil rights statutes and laws and constitutional principles prior to the last few years. I think that we're all familiar with the kind of novel approaches that the Biden administration took with regard to promulgating rules, and that would not necessarily have been consistent with prior ways of interpreting longstanding civil rights principles and statutes. And so in a lot of ways, for practitioners, this is not necessarily coming out of left field in terms of what law now applies. Really, we were more searching for answers when there were novel ways of approaching these things in the last 3 to 4 years, rather than kind of the slow building of case law and rules and administrative decisions that we could really understand what the import of the civil rights laws as they apply today. We also have some very major Supreme Court decisions that have come down over the last few years that have kind of reined in some of these recent rules. And so we're all digesting those, but from just a basic standpoint, in some ways, this just presses the reset button and puts us back into 2020 and before. And that includes 2020 as it was, where we were at in the law, as it built over successive administrations of Clinton, Bush, and Obama, and Trump's first term. This has really been a long-standing conversation, and there are established precedents as far as what you can and can't do with regard to race-based and sex-based discrimination in the K-12 scenario that at least this administration is giving a heads up that we're going back to kind of the basics. So with that, I'll turn it over to Ryan for any initial thoughts.
Yeah, I just want to start out by taking a step back and kind of talking about Josh and I and how we're involved in this process. So we work for the School Board for Academic Excellence. They're the people who we are engaged with. And so all of this information we're giving is general in nature. It's educational. It shouldn't be considered legal advice. Our client in this situation is the actual KSBRC, the KSBRC, rather than anyone else. So I just want to be clear that, we don't represent the individual school board members. So if you're a school board member and you want to go talk to your school board council, that's fine. But just know we aren't representing you. We're giving some information here and trying to be a resource in, frankly, the void of guidance in other areas. And so I just want to make that clear that, this isn't technically legal advice. Your counsel is still your board's counsel. And so they are the ones that you primarily need to rely on for legal advice. But we'd like to provide some resources and thoughts in that vein. So just kind of piggybacking on some of Josh's thoughts, one thing I do want to point out is that the executive order 14151 dealing with DEI education, I mean, that's an executive order that is published in the Federal Register. It has the force of law as to executive branch agencies. The OCR letter, the Dear Colleague letter, you might look at footnote number 3 here, and it says this document provides significant guidance under the Office of Management and Budget's final bulletin for agency good guidance practices. This guidance does not have the force and effect of law. It does not bind the public or create new legal standards. The document is designed to provide clarity to the public regarding existing legal requirements under Title VI, the Equal Protection Clause, and other federal civil rights and constitutional law principles. And then goes on to say, if you're interested in learning more, how to contact the Office of Civil Rights. So this is a point I want to make. The executive order applies to executive branch agencies. And if you read it, not only, as Josh pointed out, does it not make a private cause of action for folks, it is more information gathering in many ways. While it directs agencies to stop DEI programs, it also looks for information about grantees that may have received funding, federal funding, to make those programs or enact those programs. While the executive order and the OCR letter work in tandem, they're different. They have the same goal in some way, but the OCR letter is not new law. It's not. It's basically saying this is the way that the Office of Civil Rights interprets the Equal Protection Clause, and how the Office of Civil Rights going forward is going to interpret Title VI. And so, more than anything, it's a warning and guidance saying things are different now, and this is our interpretation, and it's the interpretation that has been for a long time. It's a long-standing interpretation, and I think the thing that Josh kind of hit on that I take away from this letter is a lot of the race-based initiatives, the DEI initiatives, are relatively new. They are more progressive in nature, and this letter is indicating that the Office of Civil Rights is taking a step back and falling back on that more solid precedent, and looking at the guidance given by the Supreme Court and Students for Fair Admissions versus Harvard on these. While, as Josh pointed out, that case did have to do with college admissions, using that same framework that the Supreme Court laid out in analyzing these DEI programs. And, as the executive order points out, it's not just programs labeled DEI, but you have to look at the substance of the program, whatever it's called. And the way that you should look at the substance of it, according to this OCR letter, is really in that framework for Students for Fair Admissions versus Harvard. And so I guess the point of this is that all of these programs exist on a spectrum. And as you the school boards and council look at these programs and whether or not they conflict with this OCR letter, you have to see where you fall on that spectrum as the Supreme Court gave its guidance. Some things are more discriminatory in practice and some things are less discriminatory in practice. And where that line actually falls is going to be very difficult to ascertain. And to some extent, the Office of Civil Rights is going to be evaluating that on whether or not they want to exert jurisdiction on any particular program. And so, I guess the point here is for prudence and not wanting to be the example, and take a progressive approach and have the Office of Civil Rights say, well, you were too far on the spectrum towards the discrimination end, and have a Title VI investigation instituted. And I think that's really what this OCR letter is doing, is more so talking about the sea change, and that these programs very well could be problematic under existing law, and to be very careful about how you approach them. And another thing that I would say is that the Office of Civil Rights will give you technical assistance if you reach out to them. If you have questions about programs, you can contact them and request technical assistance, and they can get clearance to have their attorneys review the program in question and tell you whether or not they view that it violates the law as they interpret it. And so that's something that if there's a question when you are dealing with your school board and your school board's counsel, a suggestion always can be, why don't we ask for technical assistance on this and see where we land on that spectrum. And so just to come full circle here on that Maryland Teachers Union case, I think that one will be very interesting going forward. Basic along the lines of what I'm talking about is this letter, these two letters didn't necessarily change anything. They didn't try and establish new rights like the executive order did in telling executive agencies to stop these programs. And so that case will be interesting from a standing perspective to see the court's analysis about whether anything actually changed. It's kind of a preemptive attack on these, these programs being taken away, whereas really, in my mind, the better postured case in that situation is probably if the Office of Civil Rights went after a school in Maryland on a program and asserted jurisdiction and said that it violated Title VI. At that point, this may become a defense. The claims in that case may become an offense to that school, but it'll be interesting to see, given the wording of the letter and how I interpret it, to see how that case turns on a standing perspective right at the outset. Josh, you have any other thoughts?
Yeah, just to wrap up our initial thoughts, and then and I'm sure you all want to get to, well, what about this program and what about that program? Really, at the end of the day, this is again, we don't know what we don't know in terms of how these will get postured in front of a federal court or a state court, most likely federal, as a case in controversy, versus more just, hey, we're giving you a heads up through these dear colleague letters that this is going to be our general approach. So we're giving you some time to adjust and to do some inventory of what you may have going on in your school that it somehow conflicts with these basic neutrality, racial neutrality principles, that there's kind of a ramp up to making sure that we didn't let anything go too far under the cover of a previous administration, which in some ways was threatening the opposite, that if you don't accommodate on the basis of race, on the basis of sex, and other type issues, that you could somehow be investigated by the federal government. So the real situation that's shifted here is that but prior to the current administration, if you had a racial or sex-based discrimination that occurred, that were kind of in line with these DEI, new novel DEI programs, there wasn't a lot of expectation that the federal government was going to do anything about it. And so really you had the question was, do you have a private cause of action? What has changed now is that, and those are difficult cases. They're expensive. Many times a family or a student that believes that they were discriminated against through some of these programs, novel programs, would many times have to get a public interest law firm involved. What has shifted is that now the federal government is on the other side there in terms of saying, we are going to take a very race neutral approach that's more consistent with the more original understandings of civil rights principles, and not carve out these exceptions for the need for DEI programs to accommodate historically discriminated against groups. But so there really is some more, I think, internal inventory that each school district probably needs to take now that you've got the full weight of the federal government saying that if there's anything that you might have done under the previous administration that you thought was consistent with what they're saying, that's not the case anymore. So the nice thing is that I think that there are some very clear principles in these letters that you can at least start with. I will say that there are other states and other statewide organizations, read one in California, that their advice to school districts with DEI programs is to wait and to do nothing at the current time, which is basically let them come after us type approach. And we're going to fight this in court and similar to the Maryland case and all of that. I guess what I would say is that I try to approach any of these issues from a risk tolerance standpoint, regardless of who's the current administration. The rule of law really needs to be consistent and develop over time to provide clear rules so you know how to comply with constitutional and statutory principles at the federal level. And so anything I say regarding the risks today, what we found is that in 4 years from now, if there's a change in another administration, we may be on the pendulum swing yet again, but you can only deal with what's in front of you. And at this point, the federal government is kind of is pushing back pretty strongly on anything that would tend towards some sort of different treatment regarding race and sex-based classifications. I just wanted to read a couple of those principles from this. There is the critical race DEI type curriculum aspect that this talks about. If I can find it here. And it's very strong language. Educational institutions have toxically indoctrinated students with the false premise that the United States is built upon, quote, systemic and structural racism, end quote, and advanced discriminatory policies and practices. Proponents of these discriminatory practices have attempted to further justify them, particularly during the last 4 years, under the banner of diversity, equity, and inclusion, or DEI, smuggling racial stereotypes and explicit race consciousness into everyday training, programming, and discipline. But, and this is the principle, under any banner, discrimination on the basis of race, color, or national origin is, has been, and will continue to be illegal. And then it talks about federal law thus prohibits covered entities, and that would be any entity that ultimately receives federal funds like a K through 12 district, covered entities from using race in decisions pertaining to admissions, hiring, promotion, compensation, financial aid, scholarships, prizes, administrative support, discipline, housing, graduation ceremonies, and all other aspects of student, academic, and campus life. Put simply, educational institutions may neither separate or segregate students based on race, nor distribute benefits or burdens based on race. And so the basic idea is that even though this sounds a lot like colleges, they're talking about colleges, it does include admissions and hiring practices of K through 12 districts, and promotion, compensation. It includes administrative support. I think it would, and discipline. It certainly would include potentially any surveys that you do of either your teaching staff or your students that somehow has a derogatory approach to certain races having certain characteristics, or anything like that, versus celebration of diversity and celebration of different backgrounds in a positive way that doesn't exclude students from participating in that, or shame students basically for not being a part of that club, so to speak. And so certainly at the college level, there have been issues going back years regarding if there's a automatic appointment of a certain race-based club to the student senate, or if there's an automatic appointment based on race. Those are the types of things, especially when they distribute funds or have some sort of regulatory power. Those are the types of things that get challenged in court. At the K through 12 level, many times, maybe at the high school level, there may be certain clubs and whatnot that are active. But the main principle to ask is, are we excluding people based on race? Are we giving certain benefits to people based on race, and that's the basis versus any other neutral basis that may not be a protected class. We haven't talked a lot about the sex-based Title IX sexual harassment aspect to this, but we can certainly get into that in questions. But where I would leave this is to go to your superintendents and go to your school board councils and ask them to do a preliminary review of any policies or any curriculum or any activities that involve race, involve I don't want to say special treatment, but just different treatment based on sex, and then from there analyze those, ask your school council and ask for other resources to analyze those on the basis of kind of tried and true principles that have developed in court over time to determine if they may violate the Civil Rights Act or any other principles, constitutional principles based on this guidance. And then from there, it's just a risk tolerance. I do want to talk to the belief that I think many people have that some of these programs have immense educational value. It's not a simple progressive versus conservative approach, because there may be some programs or maybe some curriculums that you would never even think of implicating some of these principles that have been around for years, that may implicate at least principles, but there may be answers to that in the court system where the courts have said, yes, there's a sex-based discrimination, but this is accomplishing a significant governmental interest. And so we're going to say that even though there is a distinct treatment, it's still legal. That's the only thing that really means is when strict scrutiny or intermediate scrutiny applies, strict scrutiny for race-based classifications and intermediate scrutiny for sex-based classifications. That's kind of a threshold to trigger this analysis of heightened scrutiny to determine how significant is the governmental interest, and does that outweigh, is it narrowly tailored, or in the case of intermediate scrutiny, is it significantly tailored towards accomplishing that? Is it tailored to accomplishing that significant governmental purpose? And so it's not as if anything that has any distinct treatment between sexes, for example, men's restroom and women's restroom, is going to be illegal. It's just that it starts triggering some of these things, and there are a lot of answers with respect to common practices. It's more the novel practices over the past 4 years that are starting to be called into question. So with that, would it be appropriate time to open up for questions?
Well, one final thought there as far as just tolerance for risk. I mean, I think a lot of the questions that we'll deal with have to do with definitions, like what is DEI? And the executive order pretty much acknowledges that it actually says that, invidious discrimination, no matter what it's called. It says forced, illegal, and immoral discrimination programs going by the name, and then DEI in all aspects of the federal government. And basically it wrestles with what is DEI and what are these programs? And so getting back to that idea of risk tolerance, there are certain programs that are closer to the line. And I think with the Office of Civil Rights issuing this guidance, I think what they're saying is that this risk tolerance issue exists because there are numerous ways for the Office of Civil Rights to open an investigation and assert jurisdiction. It can be a complaint from any student or parent, or they can do a compliance review based on news stories or other information that they come in contact with. So I guess the point is, I wouldn't be comfortable trying to fly under the radar with programs that are incredibly progressive, hoping that the Office of Civil Rights won't exert jurisdiction. I mean, that's a high risk activity in my in my mind. But getting back to the definition of where that line is, I think that's why the OCR letter really looked at Students for Fair Housing versus Harvard, because they rely on the court's explanation that classifying based on their race is unlawful unless it satisfies strict scrutiny. And you heard Josh talk about that. And so you have to have this, it has to be necessary, and it has to achieve a compelling state interest. And in that case, they really identified two, and one was remediating specific identified instances of past discrimination that violated the Constitution or a statute, or second, avoiding imminent and serious risks to human safety, like in they gave the example of prisons and like a race riot. But then it goes on, the OCR letter goes on to say nebulous concepts of racial balancing and diversity are not those compelling interests. Basically relying on the court's explanation that an individual's race may never be used against them and may not operate against a stereotype. And I think the very simple test is, as Josh said, does this curriculum treat people different based on race? And that's really the core of what the OCR letter gets at. And that's the last thing I would say before we open it to questions.
With Ward.
Josh, Ryan, a question I've been asked time and again since we even talked about having this and since these orders came out is the pronoun issue. There are many school districts that all of a sudden in the last few years have come up with everybody gets to identify with a pronoun. From what I understand, you're saying that would be a little bit different than what it was previous, and that would be questioned. Every school is going to have to take a look. If they're still doing that and they want to do it, they'll have to make that decision. Would that be the right comment to make about that?
I think, so the pronoun issue has been evolving over the past many years in court. The state legislature is taking it up currently in various bills over the past several sessions to provide advocates for certain positions on the pronoun issue. That gets broken down in a couple different places. The first is parental rights and secrecy related to the school districts hiding certain information regardless of their duties under FERPA to provide student record information to the parents. That was actually addressed in a federal case that Ryan and I participated in a couple of years ago, wherein it was found unconstitutionally as applied a practice of the school district requiring teachers to use one name in the classroom and one set of pronouns in the classroom, and then another name and another set of pronouns with the parents, and there the twain shall meet. And so I think that's the first thing, is really the parental right to information of how students, how staff and district personnel are using pronouns, and with respect to what the parents know, what they don't know. When it comes to pronoun policies that would require staff a little bit more transparently, say a parent came in and say, my child has different pronouns, identifies with a different sex or gender, and they're trying to basically accommodate the parent's request. In those situations, we don't really know at this point. I know that the executive order did establish that there are only two sexes, male and female, but that was a little bit more geared towards the federal agencies rather than kind of top-down federal law forcing every citizen in the country to now refrain from using pronouns. I don't think that that's where we're at legally at this point. And so I think the school districts are still in the situation of having to balance potential claims on the other side of sex-based discrimination with regard to pronouns, with regard to transgender issues, where there may be claims that pop up from a family that about their transgender student that feel discriminated against regarding a teacher refusing to use those pronouns. And so I think that school districts are still going to have to wrestle on both sides of that. The one thing that I think that we know from case law in Kansas, at least at the district court level, is that at least one school district has been held financially liable, or at least settled regarding a policy that would keep that information from parents or force teachers to basically lie. And what I mean by lie is use one set of pronouns with the kid in the classroom and not tell the parent that that's what they're doing, not lying about the truth of any specific set of pronouns. That hasn't been come up in court that I know of in Kansas. So I don't think that at this point the pronoun issues have been as directly involved. I think the Title IX Dear Colleague letter has more to do with sexual harassment situations. And I think that the school districts still have the ability to set policy regarding, in the absence of a state law, set policy regarding how they're going to navigate this pronoun issue, because it does implicate competing claims depending on what the fact pattern is. But I do think that one thing that would be a good question, if you're reviewing those types of policies, to reach out to the Office of Civil Rights to see if there's any federal implications for that. But right now, I think it's still being worked out in the courts, and only the most egregious situations get to a trial or something like that, because there are competing claims. And I think that even the Supreme Court recently in the Bostock decision actually was saying that there are some implications for sex-based discrimination when you do engage in sex-based discrimination in a way that, discrimination regarding transgender issues in a way that would implicate sex. And so it's a little thornier, but I don't think that the federal government at this point is the main place for where those things are being worked out.
And I think
Right.
that's also true with these OCR letters. I think the pronoun issue, I mean, the Department of Education may get there, but I don't think that's the direct thrust of these letters. It's more, boys and women's sports or transgenders in women's sports. I think that's really been the thrust of the Title IX February 4th letter, and then the Title VI letter is just about race at this point.
Yeah.
And so
and Kansas, on the sports issue, Kansas does have recent law that they passed regarding participation in at least in public schools and CASA type events that would regarding that issue of biological female or biological male competing in a sex segregated system of the other sex. And so that's where I'd point your school board attorneys to, at least at the state level. That's more of a state issue, I think, at this point.
Ward, do
Thank
you
you.
have anything else?
Well, the same thing, social and emotional learning, does that fit in any of that? That seems to be a question. Some districts made teachers incorporate that into their curriculum. They didn't want to. So do they have to? Is it changed back? Questions were asked.
I mean, I don't view, at least in the context of these Dear Colleague letters, that those are necessarily implicated.
Okay.
Do you disagree with that? I mean, these really are, sex on the Title IX issue and race on the Title VI. So I don't know that those are going to be implicated.
I do think that there's so many different things out there. Parental rights with respect to access to information of what's actually happening in the schools and what kids are being not only instructed on, but also specifically questioned on with regard to surveys. Many times those can be kind of flagging programs for the school district to say that this is under the guise of learning and education, when actually it's trying to potentially flag individual students or groups of students that may have either issues or even beliefs that are not consistent with these new curriculums. I think that there have been some concerning situations in Kansas where those types of surveys are being used. I'm familiar with surveys at the college level that would basically be a privilege, a white privilege inventory that would determine your score, your privilege score, your bias score, something like that, that I think would be directly implicated by some of these new approaches by the federal government. If you're somehow trying to either separate out students in terms of what resources they have, or target students based on kind of this implied shame that should be attached to your race, or implied any other characteristic that is an immutable, based on your immutable characteristics, somehow your either character or your obligations within the school district or generally as a citizen are somehow different. It's, I don't think that there's going to be an investigation by the Civil Rights Office of Civil Rights based on some random statement that a teacher makes in a classroom. But if there's more systemic programs like surveys or required social emotional learning type things that would start to separate out students based on various scores, those become very problematic.
Well, they have been, those surveys have been regulated by the Protection of Pupil Rights Amendment since the 70s. And so those surveys, if they get into certain questions about certain things, the parents have right to give consent to have those surveys given. And that's been a longstanding requirement.
But I do think that whole aspect of the parents have rights to do X, well, not only did they have rights in the last few years, maybe based on other laws and amendments, now the federal government is saying, if this is happening, we're going to bring the full weight of the federal government against it as well. And so I do think that this is a natural time for each school district to ask themselves, not only know what's going on as the elected overseers of the district, elected officials, know what's going on in your school, but then second, ask those questions of what is our fundamental educational purpose and what's important and what's not important. And frankly, I'm sure there will be school districts across the state that take very defensive postures towards any change, similar to other state guidance that I mentioned earlier, to say these curriculums are important, we want to keep doing it, and until told otherwise, this dear colleague letter is a bunch of hot air. I read that in a news article earlier today, and so that comes down to risk tolerance. But I think that you can ask the questions, and school elected officials certainly should ask the questions of its staff just to know what's going on, and then to have those fundamental discussions about what our educational mission is and how important certain programs are given this new change in federal enforcement policy.
Well, we have quite a few questions, so I'm going to try to filter through, but going to kind of start at the top. And as you mentioned, some of these are fairly specific and some of these probably overlap. So one of our attendees says that there's diversity training listed in the culture portion of the strategic plan. Do they need to think about removing that from their strategic plan prior to February 28th? Or are they okay with, just having not started that training?
Well, those principles, again, have to do not only with students, but also staff.
Right.
And so you're going to get a very lawyerly, it depends answer from Ryan and I on any specific facts, because, just like any other attorney, we'd have to review the specific training, the specific slides. I think we've all seen egregious examples in the news over the last 4 years or so of corporate trainings and whatnot that go overboard and kind of get into this shaming certain races or saying this is how it is. And the one thing I would note is that a lot of these types of trainings or curriculums are turnkey. They've been purchased from national organizations. I'd be careful with some of that, or just make sure that those are constantly being updated to make sure that you're hitting the main goal of that. It can't be to treat races differently, or to be derogatory towards certain races. If the goal is to celebrate, a diverse nation, a diverse workforce, and everyone's unique backgrounds and unique cultures and whatnot, I think that those would probably be less questionable in terms of from a legal standpoint. But the farther you veer into what we all have known for our entire lifetimes at this point as racial discrimination, we're very familiar with that when it comes to minority groups. And I think that since the civil rights era, we've been, as a nation, moving towards this very clear neutral principles of you cannot discriminate on the basis of race. What's happening now, though, and especially with the Harvard decision and the affirmative action that the Supreme Court is starting to go away from, is whereas before certain institutions would have been given a pass to correct for previous invidious discrimination that we all learned about in history books as far as voting laws and public accommodation laws during Jim Crow and later, that the Civil Rights Act addressed, that those affirmative action programs are starting to become more suspect, and especially with critical race theory, and especially with certain DEI programs, the way they talk about race is basically flipping it all on the head to say, now we're going to start engaging in overt discrimination against non-minority races or other races that are not don't have long-standing hundreds of years worth of discrimination in America. We're going to discrimination to correct for past discrimination. I think we're finally getting to the point in the law, at least at the federal level, of that being far more suspect. And so I would encourage you to make sure you know what is going on in your district, because you don't want to get flat-footed with a complaint that goes to the OCR and you never knew about what was being provided to teachers, what was being provided to students, and what policies existed. And then I think it's also incumbent upon the school districts to provide some guidance. I know the State Board of Education at this point hasn't provided, that I know of, any guidance, but at the local level provide some guidance to staff members of how to stay in the middle lane, so to speak, and not veer off into any type of discrimination. Obviously, you can't discriminate against minority races, but increasingly it's becoming clear that the law is also discriminating against non-minorities.
So I'm going to take quite a few questions and kind of lump them into one and maybe make this a little bit more general that will be helpful to you. And that has to do with clubs, school clubs that have to do with diversity or GLSEN clubs. Where do those fall underneath this?
All right, I can take it, or do you want to take it?
Yeah, I mean, again, it depends on how I mean, like a diversity club that allows everyone to come in and it celebrates diversity of all races, and all races are welcome to come to the club. I mean, I don't see any thing in the OCR letter that would even begin to prohibit something like that. I think the question again is, does the club under the Title VI letter treat people differently? Does it exclude certain races because they're a certain race, and just allow members of a certain race to be part of the club? And so I think, you know, you can have an African American history or culture club that is welcoming to all people, and it just of any race, and it just celebrates that that community. And I don't know that that would run afoul of anything in the OCR, depending on how the curriculum and the activities of the club play out. If they get more into, you know, demeaning other races in the context of you know, promoting other cultural aspects, I could see that being problematic. But I think it's a really generally, I don't think the clubs are really what are the focus of these letters. It's more so the overtly discriminatory trainings that we've seen to come into existence here over the last.
But if a club, for example, I mean, I don't want to get too far down the road because there's a lot of case law behind this type of stuff. But for example, if a club, you know, had a requirement that officers be only
Right.
a certain sex, a certain race, or then we can also talk about the sexual orientation, GLSEN club type things that you mentioned, because that has some different relation to the sex-based discrimination in some ways than other types of, whether it be a female athletes association or something like that. I think that as far as membership and as far as leadership and access to school resources, public resources, whether that be sponsorship or paying for certain activities or speakers or anything like that, that starts getting into the equal protection aspects of when another club asked for the same thing and didn't get it. Is the question, why is that distinction being made? And then the membership and officer aspects, I think the closer you get to, we're not going to allow a certain student based on their immutable characteristics to participate or have access to the same resources based on those characteristics, that's when you're starting to implicate strict scrutiny or intermediate scrutiny, and you could be in trouble. But there are answers to a lot of this. I don't think that the sexual orientation aspect to it, I mean, the transgender issues are different in some ways legally, because they have to do directly with a student's sex versus their sexual orientation or preferences, or and so it gets really tricky. I'd hate to say something today that would be a bright line rule for something. It's just make sure that you have those discussions with your school attorney, but every different type of potential discrimination has its own set of case law and legal principles.
Okay, well, we're at 5 o'clock. Do you want to take a couple more questions, or do we need to wrap it up?
keep going.
Okay. Well, here's another question. Federal funds come in various ways to local school boards, right? But a significant amount of the federal funding goes through the state. So, how would federal funds, or how could federal funds be withheld from one district or from another? If you have two districts, one is not in compliance, or one is not complying with the OCR letter, the other one is. How would that happen if the funds come through the state, if a significant amount of the funds come through the state?
I would probably expect, I don't know this for sure, but I would probably expect some Attorney General guidance on that at some point if it becomes a real threat. If there's some sort of letter that Kansas gets, that because they're allowing certain things to occur at the local level, and they're distributing funds, I think that would be more of a fight between the federal government and the state, especially if there are state programs that seem to reward these types of programs that at least implicate different treatment based on race or sex. I would be more concerned probably with any grants that come in from the federal government, continuing grants, that if you're using those direct funds as a school district and then appropriating them for these types of programs, that would be much more on the line. I just don't think that's as common. And I wouldn't expect that future grants, at least under this administration, would be targeting, promoting these types of initiatives that were common in the previous administration, especially given the executive orders. So it's just grant by grant. But on the state side, I would probably still ask for guidance. And, obviously the Department of Education is going to do the best it can to navigate this in the context of local control as well. But I think that the state has a very significant interest in not losing those federal funds as well. And the Attorney General's office may issue an opinion if asked in the future. And that may be something that if at the local level, you're particularly concerned about a specific grant or program or source of revenue, you have the ability to ask the Attorney General's office to issue a letter. They don't have to do it for local officials like they do for state officials. But I think it's kind of an all hands on deck moment, because at the end of the day, we all want to pursue the fundamental educational missions of the school districts and balance all of these competing interests in a way that is lawful, in a way that is constitutional. And it doesn't, that's the other piece of advice I'd give, is like, I guess don't immediately assume at the local level that everyone on your board or everyone within your staff falls on one side or the other of this big culture war that's going on. You may know that generally this person does, or generally that person does, but regardless of kind of what your policy opinions are and the debate that's going on, a lot of this is just good old-fashioned lawyering to make sure that you know what the universe is that you can engage in certain programs that are lawful. And that could look much different for an urban school than a rural school. And it doesn't have to be the same. There still is local control in Kansas, but we still need to know where the guardrails are.
Well, and I think the difficulty in answering your direct question, I think it really depends on the violation at issue that caused the withdrawal of funding. You see OCR investigations at different levels. I mean, we just saw an OCR investigation open up into the entire state of Maine. Whereas, if the violation is at the district level, those things could result in completely different outcomes. And so it really depends on what the violation at issue is.
Well, and maybe this is a good follow-up question. It's something that I was wondering while you were talking. If a Kansas K through 12 school district, has DEI programs, some of them are, as you mentioned, I think Josh, you said something about this, that some people may take the tack of, well, we're just going to sit back and wait and see. So do you think, in your opinion, what will come first, the funding cuts or the lawsuits seeking to prevent them? Do you have a take on how you think that's going to fall?
Well, I think that kind of gets back to my comments about the Maryland Teachers Union case. I mean, funding cuts aren't just going to come. I mean, there has to be some kind of compliance review or action by the Office of Civil Rights to begin that process, and then they have to find a violation. But these preemptory challenges on these OCR letters, particularly it's going to be pretty shaky to have a lawsuit saying you can't take away these programs based on that OCR letter because it didn't technically do anything. The OCR letter is just saying, hey, this is how we're going to interpret the law going forward, but it doesn't create any new law. And so
But
I'm
I
curious.
think the one thing that it does do is it removes a opposite feeling of threat from the previous administration, that if you don't do certain things,
Right,
to kind of advance the ball, that on some of the correcting past injustices, et cetera, that you're going to be investigated or lose federal funding. That's really gets back to the whole idea of, I do think that this is more of a reset button to at least take off the table that that those school districts who would have chosen to not otherwise participate in certain programs or certain curriculum, or allow certain things that have come in, especially in the last 2 to 4 years, through some sort of national push or national or nonprofit organization saying you should offer this or whatever. It does give you some breathing room now to reevaluate. Is that something that we want to do on our own accord? And if that's the case, then we need to ask our staff and our legal counsel locally to kind of to make sure that we do that in a legally compliant way. And if it's not the case, then at least there's the absence of a federal threat of funding if you don't comply with these more novel regulations. I mean, a good example is just the 2024 Title IX regulation that has been vacated by a court, and now the federal government's going back to 2020. So now we at least know what the playing field is.
Well, that kind of covers our questions. Anything else that you would like to say before we kind of have a conclusion or word? Anything you would like to?
Yeah, I mean,
Complicated, isn't it?
it is.
That's what's so interesting to me, is because when you started this, really appreciated your easy understanding of what the executive order is, that it is a way of interpretation of the law, and then talking about how it was going back to the previous understanding and the court cases, of defining those terms under the law. And so that I think is just so interesting to me, in that we're now having these questions when we are going back to what was perhaps for some much more of a overview, or what was considered to be the general accepted understanding.
Yeah, and I guess what I would leave everyone with is just, I've mentioned this during the last webinar, which is, as elected officials, as superintendents, as local council, but especially as elected officials, I want to leave you with the confidence to just ask the right questions,
Right.
and to empower you to actually govern. Because I think that there is kind of there's just too much for volunteer elected officials to kind of keep track of, and you think you know what the general principles are and what your directives to your staff are. But there's a lot of pressures, even for small districts, from national groups, national curriculum groups, and others, that somehow you have to do this, and it seems great because it may be free curriculum, it may be free resources, grants, etc. And I think where school board elected officials really need to understand their own role in this is to continually ask the questions of what is our fundamental mission, how are we accommodating different students and families and local pressures, because everyone has an opinion on pronouns, everyone has an opinion on critical race, everybody has an opinion on correcting past injustices and all of this. So that's where I really want to. I think that if your school board devolves into just a straight up vote based on culture wars, it's going to get pretty messy. And I think that to the extent that you can get back to the main things of just asking the questions, make sure you have access to all the information and not just some of the information, then from there you can kind of build back towards what your main mission is. And then if you do decide at that point that there's majority vote, or we like how this particular curriculum balances the various things and talks about these very important historical and cultural issues, there's a right way to incorporate different types of things that may implicate one side or the other of various cultural issues. And it may look very different for different school districts across the state. But you want to make sure you're not outside those guardrails, and this is a good time to ask those questions again.
And you did a terrific job of showing us where some of those resources are. Want to make sure that people will take the time to take a look at that might be helpful. And as you mentioned, ask. Reach out and ask, because that's where you'll get your answers. Anything else, Ward or Ryan or Josh?
No, thank you guys very much. Very complicated issue, but it's good advice.
Well,
Things we need to listen to.
and yeah, asking the questions, because all these programs are different. I mean, does social and emotional learning include DEI? Sometimes it does. I mean, and what is DEI, and is this a DEI program? You got to know what the curriculum is before you can answer those questions. So asking about it is the first place to start.
Well, thank you all so much. Thank you, Ryan and Josh, for joining us. We know that this is, we're at February 26th. And so there are a lot of people who are a little nervous about this, with the mandate saying February 28th is when you have to fall into compliance. And so I know that becomes a little stressful for some folks. So thank you so much for taking extra time to talk with our school board members today and those who are attending. And so we appreciate you joining us, and all of those who have attended will receive the link to the webinar in the next 48 hours. If you have suggestions for a webinar, please reach out and let us know. We'll have more webinars coming up. And always, if we can support you in your effort to be more student focused, please let us know. We appreciate your time and hope you all have a great rest of your evening. Thanks so much.
Thank you.
Bye-bye.